Hi, this is Richard Oler, ready to outline the case I talked about in video 1. Memorial Day has just ended, a day on which we remembered men and women who gave their lives to protect our right to a fair trial. The following account will show you how our legal system has been corrupted to deny us this fundamental right in certain crimes. Why? I believe it is a combination of arrogance, ignorance, incompetence, and malice. After careful reflection on true facts the jury was never allowed to hear, and the lies they were told, you decide. Substitute your name for Keith McMullin. Did you receive a fair trial? I've titled my presentation An American Tragedy. On February 1st, 2013, Keith Allen McMullin was sentenced to 25 years in prison by Judge Jeffrey Jones for a crime he did not commit. I believe these are some of the lies told the jury that led them to vote for his conviction. Page references are to the trial transcript. Lie number 1, testimony by his 13-year-old accuser who stated that she was raped 2 to 3 times per week for the last 18 months, page 66 to 72. Lie number 2, opening statement by the prosecutor, Stacy Boardman, who said there is no physical evidence in this case. Isn't the normal hymen physical evidence? Page 28. Lie number 3, testimony by the medical expert, a certified nurse practitioner, Christine Smith, who stated that she was as qualified as an MD to do her job. She testified that in this case and others like it, she expected to find a normal hymen. In this case, she found a normal hymen and documented it with a video of the exam. No qualified MD or DO would so testify. Page 311 and 312. Lie number 4. In her closing statement, the prosecutor said this whole hymen business is a myth and all sexually active teenagers have normal hymens because we are designed to have sex with each other. This statement is such a flat-out lie that anyone making such a statement has no business being involved in a case where someone's life is at stake. A judge who is so uninformed medically that he allows planting of false evidence in his courtroom also has no business in making life and death decisions. Page 625. Lie number 5. All the child abuse, sexual assault experts from Child Protective Services had no knowledge of anything involved in this case except what the accuser had told them. Yet all were allowed to vouch for the veracity of her testimony and by implication that Keith was lying. Why was this allowed? No such vouching was allowed Keith McMullin. Lie number 6. In his jury instructions, Judge Jones stated that the jurors needed to consider, and I quote, evidence concerning the character of the witness for truthfulness, end of quote. Page 630, 631. He and the 2 attorneys agreed before the trial began that no one would be allowed to testify about the character of the accuser. See the pretrial discussion. There are many pages. There were several adult and teenage witnesses who had known the accuser and the accused for years, but were not allowed to testify about their character and reputation for truthfulness. Why? See lie number 5. The experts who had interviewed the accuser for a few minutes, or in one case a couple of hours, and never had talked to the accused, were allowed to vouch for her story. I find this truly amazing logic. Lie number 7. Judge Jones congratulated the two attorneys on their professionalism in this case. Page 665. Is he really so unfamiliar with the law that he did not recognize incompetent conduct, which would be considered malpractice in any other professional field? As you examine this case, consider the conduct of these professionals. Here is a simple comparison. A surgeon who operated without washing his hands or wearing gloves, resulting in serious infection, would be subject to malpractice for certain and possibly even criminal misconduct. Should not these courtroom professionals be held to similar standards? Look at the mayhem they created in the life of Keith McMullin and his family through their actions. Where was the attention and focus of Keith's defense attorney during the trial? Heather Karabika was obviously in the courtroom. Was there a conflict of interest? Did she not want to rock the boat by doing her job because she was soon to be appointed a judge? Only she can answer that. I was informed that Miss Karabika was briefed by at least 2 other attorneys before the trial about what she should expect during the trial. Did she pay attention to this advice? There were legal cases already decided that apparently addressed some of the very medical issues raised in this case. She knew or should have known about these cases. Why didn't she use these to help Keith? Why did she not call a qualified medical expert to refute the false testimony given by Christine Smith? These facts were pointed out in the Ryan Scott letter, see the blog. Why did she not question Christine Smith about her qualifications to be called as a medical expert? Why did she not challenge the Child Protective Service witnesses who were called by the prosecution to vouch for the veracity of the accuser? According to the appeals attorney, if no objection is raised by the defense attorney to lies and procedures during trial, there may be no legal basis to grant an appeal, even if the conviction is based on these lies. Why did she not question the medical study cited by Christine Smith? Why did she not ask Ms. Smith about some of the other medical studies available to her, especially the slaughter study of 213 victims, in which 92% had evidence of sexual trauma if examined within 48 hours of the attack? The 81 adolescents included in this study had 100% evidence of sexual assault if examined within 48 hours. None of several other studies agreed with the Kellogg study on which Ms. Smith based her expert opinion. One of the main criterion of a valid study is that it can be and is repeated by other investigators with the same outcome. Why did Ms. Karabika not ask Ms. Smith to explain this? It defies all logic that among the judge, the 2 attorneys, the medical expert, and all the sex abuse experts from Child Protective Services, not one questioned the accuser's story in light of her normal hymen. No one questioned Miss Smith's report. The 2 attorneys had my statement that I knew it was a medical impossibility. Is this why I was not called as a witness? The judge also knew before sentencing, because I had told him in a letter it was impossible. He also received a letter from a layman, Brian McNeil, questioning a normal hymen in a petite girl who testified of at least 100 rapes by an adult male. Even if none of them believed me, an experienced physician, or an obviously intelligent layman with common sense, they should at least have had the professionalism to check with other qualified medical experts before condemning an innocent man to possible death at the hands of imprisoned felons who don't like child molesters. The judge and the 2 attorneys knew or should have known about the previous legal cases that had already addressed some of these very issues. Why did they choose to lie about the facts to convict a man they had every reason to know was innocent? It would be interesting to hear them explain their actions in this case. I have known and associated with many fine lawyers, nurses, and paramedics over my years of practice. I have learned much from their insight and knowledge, and hopefully contributed to their understanding of some medical issues. We all can and do make mistakes, but such blatant errors when the life of this man and his family was at stake is inexcusable. The truth had been pointed out to them before and after the trial, but definitely before sentencing. How would you like to be in Keith McMullin's shoes? He has now been in prison for over a year. His family is struggling and recently lost their home. I don't really like to think all the persons involved in this case acted with malice, but the result of their arrogant, ignorant, and incompetent actions have brought about great harm to an innocent man and his family. If they did not have evil intent and acted out of pure ignorance, it is now time for them to step forward and correct their malignant actions. They need to admit the lies and mistakes made during this trial and get this innocent man out of prison and back to his family now. If there was malice and evil intent is still present, this foursome will not look to find the truth, but will do their best to attack my credibility. They will also use every conceivable legal trick to bully me and any other people who speak the truth. However, the case still boils down to two questions that need to be answered yes by a qualified family physician or OB/GYN specialist. Question 1. Would you expect a petite 13-year-old girl who had been sexually penetrated by an adult male 2 to 3 times per week for 18 months to still have a normal hymen? Question number 2. Is this whole hymen business a myth and all sexually active teenagers have normal hymens because we are designed to have sex with each other? No valid study supports either conclusion, nor would any qualified physician. YouTube in American Tragedy 3 will discuss the response of our governor and the various elected and appointed entities who are charged with overseeing justice for our citizens. Thank you. Now let's go to number 3.